everybody. Welcome to the Village of Sleepy Hollow Zoning Board of Appeals. This is Wednesday, October 21st, 2020, and I will start with the first item of the agenda was withdrawn. That's the application of Elizabeth and Rashid Tabi. So we'll proceed to number 2, which is Michael and Christine Glynn. And I'll read the public notice. Please take notice that the Zoning Board of Appeals of the Village of Sleepy Hollow will hold a public hearing on Wednesday, October 21st at 8 p.m. to hear and consider the application by Michael and Christine Glynn to install air conditioning condensers at the existing single-family residence where the following variances from Chapter 450 of the Code of the Village of Sleepy Hollow are required. Article 6, 450-34B, applicability of regulations, adding to and altering an existing non-conforming building, minimum lot area 15,000 feet, existing lot area 14,266 feet, minimum lot width 100 feet, existing lot width 97 feet, minimum front yard setback 30 feet, existing front yard setback 29.8 feet. Number 2, Article 6, 450-35, Schedule of Regulations, minimum one side yard setback 10 feet, existing one side yard setback 12.93 feet, proposed one side yard setback 7.88 feet. The property involved in the application is located at 37 Hemlock Drive. It's situated in the R2A zoning district and is shown on town tax assessment maps as section 110.11, block 1, lot 41. A copy of the application and accompanying documents are available for review at the Department of Architecture, Land Use Development, Buildings, and Building Compliance during normal business hours, or may be reviewed and downloaded from the village's website. All people are entitled to attend and be heard at this public hearing. Village Hall is accessible to persons with disabilities. Sean, are all the returns in? Yes. Okay, please.
Okay, my name is Amanda Linhart. I'm the architect for Michael and Christine Glynn. The project started with an interior renovation. They had air conditioning on the first floor only, and so we decided to split it into 2 zones and add air conditioning for the second floor. They have an existing air conditioning condenser. You can see, I'm gonna stand up, hopefully this mic can get me. Here next to their chimney, which exceeded the setback requirement on the side. We want to add another air conditioning condenser next to that existing one, so that will also exceed the setback. It will be 7.9 feet instead of the required 10. The front yard setback is an existing non-conformity of the house. The neighbors, Michael has spoken to the neighbors and have received no objections. It's been there for a while. I think initially there was no permit opened before they bought the house for the existing air conditioning, so we're kind of getting that legalized as well as adding the next one.
And I apologize, I didn't read the documents that we had before us, but we have the Zoning Board of Appeals application, we have the zoning compliance form, we have the short environmental assessment form, and we have photographs, the Westchester County recording endorsement page, we have the deed, and we have the Glynn residence plans, and I believe we received a letter of support from the neighbor today. I don't have it in front of me, so I don't know the name off the top of my head.
It was from across the street. Toby, yeah. Yeah.
Thank you.
Across the street, yeah.
Right. 34 Hemlock, right?
Yep.
That's correct. Yeah. So does the board have any questions about this application? No. Okay, I'll make a motion to open the public hearing.
Second.
All in favor?
Aye.
Aye. Is anyone from the public who would like to speak today about this application? I'll make a motion to close the public hearing.
Second.
All in favor?
Aye.
So thank you for the application. I think quite clear that there'll be no undesirable aesthetic change to the neighborhood, that this is a reasonable, feasible alternative, that it's not a substantial variance. It has absolutely no physical, environmental impact in the neighborhood, and although it's a self-created hardship, that's not the only consideration we have when we grant these area variances. So I would make a motion to approve the application.
Second.
All in favor?
Aye.
Thank
Thank
you.
you very much.
Do you want any of the extra plans?
Sure. Do you want to just, I don't know how I should collect them.
Just right through here.
Thank you. Thank you very much. Thank you.
Excuse me, I missed this
Oh,
one.
thanks.
My pleasure.
Moving to application 3, Russell and Hope McAdam. Please take notice that the Zoning Board of Appeals of the Village of Sleepy Hollow will hold a public hearing on Wednesday, October 21st, 2020, at 8 p.m. to hear and consider the application by Russell and Hope McAdam to construct a patio addition to the existing single-family residence where the following variance from Chapter 450 of the Code of the Village of Sleepy Hollow is required. 1, Article 6, 450-35, Schedule of Regulations, minimum rear yard setback 25 feet, existing rear yard setback 26 feet, proposed rear yard setback 15.67 feet. The property involved in the application is located at 7 Farrington Avenue, is situated in the R2 zoning district, and is shown on town tax assessment maps as section 110.19, Block 1, Lot 74. A copy of the application and accompanying documents are available for review at the Department of Architecture, Land Use Development, Buildings and Building Compliance during normal business hours, or may be reviewed and downloaded from the village's website. All people are entitled to attend and be heard at this public hearing. Village Hall is accessible to persons with disabilities. Pamela, are all the returns in?
Yes, they are.
So I have before me the letter from the Village of Sleepy Hollow to Russell and Hope McAdam dated September 2nd, 2020, the Board of Appeals application. I also have Part 4 of the application, the short environmental assessment form, it looks like the deed to the property, a photograph stating the patio will be made of natural stone. The patio will not have any elevation above the current lawn area. And the plans for the McAdam resident titled Construction Documents dated September 11, 2020. So thank you, you may proceed.
Oh, okay. This is the layout.
If you could just tell us, tell us your name and.
Oh, sorry, I'm Hope McAdam. Hi, Greta. She took good care of me in the hospital. I'm being treated for leukemia right now, and we just thought that it would be a nice addition to our home to add a flat patio. And then we realized that we were close enough to the neighbors in the back. So it's just a flat, loose stone patio, and that's what we wanted to do.
Okay. So there's no elevation to the patio whatsoever? You're going to excavate, put in the bluestone, and you're not going to have, you're not asking for an elevated deck of any type.
And there's no plan to cover this?
Excuse me?
There's not going to be a covered patio?
No.
Is there going to be a railing around the patio of any type?
No, because it's flat. The back of our house is totally flat, and we're just putting a patio down.
Does the board have any further questions?
No.
Nobody else.
Okay, I make a motion to open the public hearing.
Second.
All in favor?
Aye.
And
Is there anyone from the public who would like to speak on the application? Make a motion to close the public hearing.
second.
All in favor?
Aye.
Unless any board member wants to comment or make a motion, I can do it.
All notices went out, I would assume?
So I, think of patio, flat patio in the backyard is very standard for the neighborhood. It certainly doesn't constitute an undesirable change to the neighborhood. It's not a large elevated deck, so it's a feasible alternative. It's probably the most de minimis alternative that you can propose. It's not a substantial variance given that it's flat, not elevated. I don't see there having any physical environmental impact, and although it's self-created, that's not the only consideration we have in granting an area variance. I just would note that this is an application for a ground level patio, not an elevated deck. So if we grant a ground level patio, I would expect that if you wanted to elevate this patio at some future date, or maybe the next property owner, they would have to come back before the zoning board of appeals. But other than that, I would make a motion to grant the application.
Second.
All in favor?
Aye.
Thank you.
Thanks very much.
Again, do you want your extra plans?
You're doing good.
I'm doing pretty well.
And keep it up.
Feeling a little shaky, but I'm okay. Thank you.
Do you want
You know
these,
how to get me.
do you want the extra
Oh,
plans?
Do you want extra plans?
Thank you. Moving to application 4, Rose Venditti, executor, estate of Maria Quadrado. Hope I have that right. I'm going to read the public notice. Please take notice that the Zoning Board of Appeals of the Village of Sleepy Hollow will hold a public hearing on Wednesday, October 21st, 2020, at 8 p.m. to hear and consider the application by Rose Venditti, executor of the estate of Maria Quadrado, seeking a determination in accordance with Article X11, Section 450-80A2 of the Code of the Village of Sleepy Hollow, alleging that the building inspector is in error for his denial to issue a certificate of occupancy for a 3-family residence. The property involved in the application is located at 123 New Broadway, is situated in the R4 zoning district, and is shown on town tax assessment maps as Section 115.7, Block 3, Lot 38. Copy of the application and the accompanying documents are available for review at the Department of Architecture, Land Use Development, Buildings, and Building Compliance during normal business hours, or may be reviewed and downloaded from the village's website. All people are entitled to attend and be heard at this public hearing. Village Hall is accessible to persons with disabilities. Pamela, are all the returns in? And just to clarify, I live at 85 New Broadway. I didn't receive a notice, so I assume that means I'm not in the notice area. Okay.
I don't have the list in the folder, but.
Right. I'm just announcing it just to be certain,
Yes,
So-
we sent out all 40 notices that were required by the list we got from the village.
Okay, well, I'm just letting you know, I did not receive one, so I assume I'm not in the notice area. So before me, I have the Zoning Board of Appeals application. which includes all parts 1 through 4. I have a letter dated September 8th, 2020, from the Village of Sleepy Hollow to David Venditti. Am I pronouncing that correctly?
Correct, yes.
Thank you. I have several documents attached to it. The Building Department of North Tarrytown Certificate of Occupancy, dated July 9th, 1979, a June 19th, 1979 letter from Victor Page. Again, excuse me. It looks like the area variance application. The short environmental assessment form. Photographs of the property. Tax parcel maps. And the September 14, 2020 letter addressed to the Zoning Board of Appeals, which attaches various documents itself, which I won't read for now, but are available to the public. I read your letter. I'm just going to start with my first question, which is really, what power does the Zoning Board of Appeals have to review a decision like this? And I'll explain. At the Zoning Board of Appeals, our power and duties are in, I believe it's Chapter 45080 of the Village Code. And that Village Code says we have the power to interpret zoning law and the official zoning map. We have the power in Section B to decide special permits. In Section C, that gives us authority to grant variances, either use variances or area variances. And then Section D, temporary uses. And that's all we have. We don't have authority to do any more, as I understand it, other than to do what's in that code. And I think what you're asking tonight is for us to review the building department's decision to record this as a two-family and not as a three-family. So you're not asking us for a use variance, you're not asking us for an area variance, you're asking us to review a decision made by the building department.
Correct.
And I'm just not sure that the Zoning Board of Appeals has that authority in the village code. So
Okay.
I'd like to hear either from
Sure.
you, and then perhaps next our village attorney who's here tonight,
Okay.
whether we have authority to make any decision on this application.
If I could start, first, I thank you very much for having us tonight, Honorable Chairman, members of the board.
Is this part of the public hearing?
Yes.
Would you-
I'm happy to hear if that he's considered it, and I think it's fair to the applicant to hear if he's.
But if you want it to be a part of the public hearing, you need to move it and open it.
I apologize. So I open. Well, no, this is the application, right? Then we open the public hearing after we hear
After
the
the
application.
application.
It's whenever you want to do it.
Okay.
Yes.
All right. So I think it'd be fair to the applicant if you tell us why you think the Zoning Board of Appeals can review the building department's decision in this matter, whether that's really in our remit or our authority.
Okay, thank you. And as I was saying, thank you for having me here tonight. I'm David Venditti of Gaines, Novick, Ponzini, Casso, and Venditti, here for the applicant, which, as you can tell from the last name, is also a very important client. She's my spouse. She's the executrix of the estate of Maria Quadrado, who is her aunt. To go first to you, before I get into the application, to go to your question, yes, I believe you sit as a Board of Appeals, including appeals of denials of the building department, and even as referenced in Mr. McCarthy's letter to us of September 8th, 2020, in accordance with Chapter 450 of the Code of the Village of Sleepy Hollow, you may appeal this decision to the Village of Sleepy Hollow Zoning Board of Appeals. So we're not here for a variance. We're here for you acting and sitting in your capacity as basically the appellate court with respect to a denial of the building department, which I believe you are authorized to entertain, and certainly as the building inspector believes that you are authorized to entertain, and I would let village council opine further on that.
Yes, sir, the village, or excuse me, not the village code, but New York State village law says specifically that you do have the authority to hear and either affirm or overrule whatever decisions might be, in this case, coming from the building department. And that you have, and to that end, shall have all of the powers of the administrative official from whose order, requirement, decision, interpretation, or determination the appeal is taken. So you do have authority to hear it, and you have the authority to institute your decision in the stead of the building department.
Okay. And that's from New York State law. It's not in the village code, but it's in New York State law.
It's New York State law, yes, sir.
Okay.
Okay.
Well, thank you. Okay, having cleared that hurdle,
Okay.
I think maybe time for you to go ahead with the application.
Thank you for bearing with me.
Okay.
As you know, the property is at 123 New Broadway, Sleepy Hollow. We provided a picture of the property in the packet so you could have some context. The third apartment, which we call the basement apartment, is not really a basement. There actually is even a concrete basement underneath. It's a sloping contour of the property, so it's above grade in the back. And as we just discussed, this isn't an application for a variance, but rather under law, an appeal of the decision of the building inspector denying not just the issuance, but basically the reissuance, because there is a certificate of occupancy that was duly issued in 1979 with respect to this property. So really, the denial results in a nullification of what is otherwise a valid and subsisting certificate of occupancy, number 423, duly issued on July 9th, 1979. And I think that's both unusual and problematic for the village and its residents, who rely, along with their mortgage lenders, on official documentation issued by the village through its duly authorized officials. Referring you to that valid and subsisting certificate of occupancy signed not once, but twice by village building inspector Page, the legal certificate indicates that, quote, "This is a three-family non-conforming building and may continue as such. This C of O covers the enclosed rear porches," end quote. So that was the valid and subsisting certificate of occupancy that was issued by the duly authorized building inspector, Victor Page, in 1979.
Can I just interrupt you?
Yes?
Is this certificate of occupancy in the file of the building department?
Well, that's a very good question. I assume it is. It was also supplied in the request to the building department for all the documents they cited in their records. It's also referenced in the logbook. I mean, I don't know if as certificate of occupancy number 423, it's referenced July 9th, 1979, as a certificate of occupancy as forwarded to the town of Mount Pleasant contemporaneously with its issue. So while we were not given the file, we met with the building inspector. I can't tell you what is in your file or not in your file, only that we were able to locate it.
Where were you able to locate it?
Okay. My wife, who's the executrix, her
My
aunt.
aunt had a lot of paper. I was going through files.
Could you just state your name?
My name is Rose Venditti. I am the executrix for the estate of Maria Quadrado. My aunt had a lot of paper, and in going through it, I mean, canceled checks from the early 70s, tax returns. In going through it, I was sorting through papers in case there was something that I should keep permanently, and I found it.
That was in the house next door. Her aunt and uncle died first, then the aunt. They owned 123 New Broadway. They owned next door that they bought in 1971, 121 New Broadway, which is under contract to sell, so it was in the context of cleaning that basement out as well. And they own 20 Maple Street next door to Inspector McCarthy, which they sold last year. But that's not the only document that the village issued with respect to the CO. And I have with me tonight, too, after I'm done, Judge Robert Ponzini, who you'll see on the letterhead of two of those documents from 79 and 80, was village counsel at that time, and he can speak to the regularity of those documents. At any rate, to give you a little bit more context with this, and with respect to the other indications of this certificate of occupancy, it was issued in July of 79, clearly in the regular course of a sale of that property. It was issued not to the aunt and uncle, but to Giardina, who was selling the next month in August of 79 to the aunt and uncle. And at the time, and this is also very important, Westchester Land Records indicates that at the same time of the purchase in 79, they took out a mortgage with Tarrytown and North Tarrytown Savings and Loan. They would have lent that money as a three-family, based upon a valid and subsisting certificate of occupancy duly issued by a village official in the village of Tarrytown.
You're saying that the bank would not have lent the money unless it was a three-family?
Well, in 1979, I was still in school. But I'm telling you now, after practicing land use and real estate for 35 years, that would have been required by the bank in closing the mortgage for the purchase of the house. And they would have made an income assessment on the 3 apartments in order to justify lending that money.
Okay, but
This
we
is going to
don't-
become problematic for many, many people within this village if a 40-something-year-old certificate of occupancy is now called into question when they may still have an existing mortgage that they could be thrown into default on, because now the village is basically nullifying a previously issued certificate of occupancy.
Okay, but we don't have anything, any documents in front of us that shows that the bank, when providing a mortgage in 1979.
No, not from 1979. I'm just going
Went
from
through
land
that
records. There was a
assessment.
contemporaneous mortgage at the same time, and that would have been regular and standard course. And that would have been why this certificate of occupancy would have been issued at that time. Indeed, even before this certificate of occupancy, the village inspector, again in his official capacity with authority granted to him by his office, issued what is known as a no violations legal predate letter dated June 19, 1979, 2 months prior to the purchase by the Quadrados, obviously in anticipation of the Giardinas marketing the house, indicating again, quote, "This building is a 3-family non-conforming building, and such use may be continued in its present status," end quote. This is again signed not once, but twice by Inspector Page, just as the CO. Not ending there, the village issued yet another official document, again, with Robert Ponzini listed on the letter as village counsel, on September 8, 1980, making it clear and stating on the record that, quote, "Please be advised that village records indicate a certificate of occupancy number 423, the one referred to with the 3-family reference, was issued to G. Giardina of 123 New Broadway, North Tarrytown." Apparently also in 1979, the village of North Tarrytown maintained a CO building records handwritten logbook of sorts. This book, that we got copies of from Building Inspector McCarthy, confirms that the CO 423 was issued to G. Giardina, 123 New Broadway, in July of 1979, this same 3-family certificate of occupancy. However, confirmation of the legal 3-family status by the village building department charged with code enforcement does not end in the 70s or even the 80s, or with the building department headed by Victor Page. Indeed, in the late 1990s, December 22, 1997, and November 26, 1997 to be more exact, and by now, Village of Sleepy Hollow inspected 123 New Broadway. These documents are attached. Apparently, there had been a stove malfunction and a repair issue in the basement apartment. Really above grade, as we told you about. If you look at page 2 of that letter, the sheet entitled Sleepy Hollow Code Enforcement Program, inspection dated 11/26/97, inspected by Barry McLean, the code enforcement officer, indicates that 123 New Broadway is a, quote, multiple dwelling, 3-family home, end quote. Importantly, and they were into the third unit, importantly, as a result of that inspection, no violation was issued for unlawful use, as it was a legal 3-family with a prior certificate of occupancy, a prior predate letter, and other documentation supporting it. It's really unheard of to now have to defend a certificate of occupancy that was issued 40-something years ago. Now, while not sufficient proof on its own, there's further, and it's to be viewed in conjunction with other village records that the village has maintained for 123 New Broadway, and taxed for same as a 230, 3-family residence for years and years and years. We attached the 2017 assessment roll showing the 3-family status, 2016, 2018 tax receipts, also, I guess, from that box of papers that she located, showing its 230, 3-family status. But now we look to the historical village and town of Mount Pleasant record cards. The village building records shows an indication of 3-family use.
Can
With
you,
a notate-
can you just hold up the document you're referring to?
Oh,
I think that would help the board. Whenever you run
Sure.
through the documents, hold them up.
Okay, in fact, I can give you a recap because I did index them.
It's okay, I read it.
Very quickly, number 1 was just the picture that I had told you about. Number 2 is the denial letter that we're appealing from. Number 3 is the CO 423. This is a legal 3-family. We have a color copy also of the original. Number 4 is their deed. Number 5 is the predate letter that indicates Ralph J. Ponzini, Village Council, June of 1979, that also states it's a 3-family dwelling. 6 was the 1979 permit and CO log, showing again that CO number 423 in your village records.
What does the 423 stand for?
That's the certificate of occupancy number for the 3-family home. It's CO number
It
423.
refers back to the certificate.
Yep,
Okay.
always, consistently. Then we have the letter that I think we were just on.
The building record.
I'm sorry, the one before that, the 1997 Code Enforcement Program Inspection, 123 New Broadway, multiple dwelling, 3-family. Then, I think we're up to present time, present comments.
So show me the relevance of the December 22nd, 97.
Well, it's just another supporting factor showing that, in the village's view, this has been a 3-family house.
Where does it say that?
Would you?
That's the reference.
Yes, I could. Would you like me to just approach? I have it highlighted here.
No,
Okay.
it's on the top right, correct?
Multiple dwelling, 3-family.
Okay.
And this was on an actual physical inspection of the premises that had been peaceably operated as a 3-family pursuant to the certificate of occupancy for years and years and years. All right. Then we have the assessment roll that I referred you to, and I'll hold that up. 230, 3-family house, the assessment roll, which, by the way, under state law, every year the village board has to sit and adopt the assessment roll by resolution, agreeing with the assessments that are in. So for every year, they adopted and approved the 3-family classification. Why? Because it was consistent with all of the village records and the approvals granted by this village. Now we go to historical building records. And we have Village of, I guess at the time, North Tarrytown record, 3-family, 1976, someone wrote in parentheses, which is the date, I guess, that they first noted that in this card. We also go to the town of Mount Pleasant. And again, as I said, these latter documents, while one by themselves are not sufficient to confer legal status, when taken together with everything that this village has issued, makes it clear that this was the consistent position of the village. Here's the town of Mount Pleasant, and they reference in their notes, I went there and I got there from 1963, the historical records. And it's noted right in here. Certificate of occupancy number 423, 779. Now, there was a comment in the denial letter, which I do have to disagree with, that said that was because in 1979, the town of Mount Pleasant made a decision to put that there because it was being used contrary to its designated use. That's not what happened. Town of Mount Pleasant inspects no properties in the village of Sleepy Hollow. I just recently confirmed this with Building Inspector Sal Pinelli in Mount Pleasant. They receive the documents from the village, and that's what they enter onto their property record cards. They don't come here and independently inspect village properties. So that shows you that the village also sent to them, contemporaneous with its issue, the 3-family certificate of occupancy. So where are we today? We have a predate letter, a valid and subsisting certificate of occupancy. In the second decade afterwards, confirmation by the building department of its use as a 3-family residence with no violation. We have the tax rolls, we have the village card, the town card, and everything that's ever been issued up until now. This has been used open and notoriously as a 3-family for probably well past 40 or 50 years. You know, it seems to me that the basis of denial is that the building inspector doesn't find documents that support its change from a 2-family to a 3-family. Well, I'm not sure when your zoning code was adopted, whether it was 65 or what year it was, but it's obvious that in all towns, not just the village, and I don't condemn the village for it, but these are ancient documents. Who knows where they were held, where they were put, if they might have been destroyed, if there wasn't good record keeping back in the 20s, 30s, 40s, 50s. In fact, really the denial letter points out the fact that you have incomplete records when it talks about in 1929, two-family building permit. But you know what it doesn't talk about? There's no certificate of occupancy, yet there's never been an indication that there's an open permit. It talks about 1955, and that was almost 100 years ago, you have to realize. We don't know what actually was ultimately built there. 1955 permit to add 2 dormers. No certificate of occupancy or certificate of compliance. Obviously, there had to be one issued back then, but goodness knows where that is today. A 1959 permit 339 to erect 3 open porches to the dwelling. Again, there seems to be no record of a CO closure or a certificate of completion. So it's obvious that there are village records that over 100 years are not maintained exactly the way this current building department maintains its records in a very diligent fashion. So I don't mention these things as and interesting about the 3 open porches. That's 3 open porches in 1959 for the 3 units. You know, so it was, you know, that's probably a pretty good indication how long ago this property was being used as a 3-family. So I don't mention these instances as a failing on the part of the building department, but just as a reality that ancient record keeping is problematic for all Hudson Valley communities. And the fact that this building department can't find paperwork that makes it feel comfortable with a validly issued certificate of occupancy of this village over 40 years ago should not be put on the innocent homeowner. I mean, if the building department issues an approval today, a certification today, should that homeowner or that homeowner's bank take that certificate to task with the building inspector and say, prove to me that you're making a good exercise of your authority, and that should everything be questioned to make sure? So 20 years from now, if the board takes the position that you can have a nullification of a valid and subsisting certificate of occupancy, what can be relied on? What certification from this village can ever be relied on 20 years from now? Is somebody going to have their CO that was issued last week nullified? That's really not a way that the village should operate.
What certificate of occupancy is in the Village of Sleepy Hollow's file? What,
Again, I don't know how they maintain their records, and I was never given their file. But here you go, in color, and we didn't have color in '79. Here's the,
that color document, that's a document that you've found, correct?
yeah,
Okay.
423, the certificate of occupancy. Is the village taking the position
Does,
that this isn't the certificate of occupancy?
I'm not asking you, Sean, what does the Village of Sleepy Hollow certificate number 423 state? If it has it.
We don't have the same document that the applicant is showing you. We have the ledger entry into the book, in the ledger book, that indicates the certificate number and who it was issued to.
So it doesn't indicate the number of family.
It does not indicate the number of families. However, do you want to finish and then I'll go, or?
Yes, that's fine.
Okay.
So I can't speak for what became of the record that the village admits as certificate of occupancy number 423. And everything else that we have says the same thing. The predate letter, the CO.
May I ask a question, or do you want to wait?
No, please do.
Okay, and perhaps, Sean, you can jump in and help me with this. In my experience, a certificate of occupancy is issued when, in response to a building permit being issued, work being done, and making sure that the work being done is to code. This all seems to hinge on a C of O that doesn't state what it's for.
May I just answer that quickly, because that's not entirely correct?
Okay.
In fact, the procedure right now for the Village of Sleepy Hollow, and this is how this all started. We were in contract last year to sell this house
Yes.
as a three-family, and, you know, in prompting from our real estate broker, he said, go down to the village, because the house is old, and get proof of a three-family, because all the other records say it's a three-family, building card, the tax rolls, et cetera. So she went down and spoke with Ray, who's wonderful, and looked at the file, and said, yeah, it appears to be a three-family, but the procedure in Sleepy Hollow is if you're selling a three-family, you must, each time you sell, apply for a certificate of occupancy. Not in connection with a permit that you've done or work that you've done, you just have to apply. So we applied, and that's when they came out and did an inspection. And Mr. Pava, and I was kind of shocked too now that we found this, because he issued a letter that we were denied and we were in violation because the basement was being occupied without the benefit of a certificate of occupancy. We hadn't found this document yet until 121 was cleared out. So no, COs are not issued.
You have a C of O saying that the basement
Well,
apartment?
that's the only 3 apartments in the house. That's the only 3 apartments. There's the basement, first floor, and second floor. That's it.
Okay, I also see in this package, or saw in this package, that the actual, of course, there is history here. The village has done a lot to make basement apartments legal, healthy, and what my reading of this is that it doesn't sound like it meets any kind of code. The ceilings are too low, there's some danger, there's a problem with egress, so it gets more complicated.
Well, what the building department didn't mention in their letter is that when we lost the sale, because we were told there was nothing indicating there was a three-family, we then, in trying to be good and doing our diligent work, we vacated the basement apartment, engaged an architect at significant expense to make the improvements to attach it to the first floor, and applied to New York State for a variance for height, for those deficiencies. And the letter didn't mention that New York State granted those variances, and without question. So it was a very standard thing. And the letter that we have was this basement apartment was inspected in 1997.
Let me look at that.
So is
So there are many things that kind of predate and are not up to today's code, but that doesn't mean that in every old house that they get shut down.
Is there any dispute that when the building was built, the original building permit was for a two-family frame house? And that was
I can't answer that question. I've never seen it. I've only seen the letter from Mr. McCarthy. I have no reason to think that he would ever not tell the truth, but I don't know if he's taking that from a ledger or an actual permit. And again, we don't know what was built almost 100 years ago because there's no reference to a certificate of occupancy, which would normally be issued after a building permit is completed. So
Well,
I can't answer the question. That makes me have to know what's in the village's files, and we don't.
did you FOIA the file? Did you?
We made a request that Mr. McCarthy complied with, and again, I have no doubt that he would give me what we asked for. We asked for everything he cited in his letter, as well as our submissions, and we received these documents back, but we did not get the 1929 building permit.
I don't think he says I don't think he says he has the permit. I think he says he has the ledger.
That's correct, Mr. Chairman. All those documents that precede the 1970s are indicated in the ledger book.
But that's not what the letter says. The letter says, in response to your request for the issuance of a three-family CO for the above referenced property, I have reviewed the following.
Right.
Okay?
And it lists the ledger entry.
It says the original building permit, that date, so it's not clear, dated July 19th, 1928, was issued for a two-family frame.
Right. And we
Is
made a
recorded
copy
in
of
the
that.
village building ledger on
Recorded-
page 24.
Correct.
Yeah, but I
And
don't
and you
know-
received a copy of that, as well as the whole entire file, which was also foiled. It was also disclosed to personally review those documents and the ledgers themselves. We've gone through these documents numerous times, both myself and my staff, to see if we could find anything in those records that could link any type of use for three-family use prior to the 1979 documents. And as this board all knows, and you've been well-versed in hearing appeals for use variances, and the date that has been used, for as long as I know, is the 1964 readoption of the zoning code. Now,
Right.
we have the zoning code dating back to 1926, which requires permits and COs. We have the 37 version. We have the 46 version. We have all of them. Those requirements have never changed. Okay, so there was always a requirement to get a building permit, to get a CO, and also the establishment of the zoning board. So that's one of the things that is drastically lacking in this application. We acknowledge this apartment has been there for a long time, prior to 79. The age and the material, and I see their architect back there, could probably attest to the same. There's no doubt that the previous owner bought it that way. That's why there's all this activity in 1979. What they fail to prove out, and what the records not that they don't prove out, they don't exist. Because, again, we have the other documents from 28 to 55 to 52, all these other permits that existed, and some of them have COs, some don't. The failure to get an approval from the zoning board is a big issue,
Mm-hmm.
big issue. I don't see where I have the authority to change a CO or to continue, as our code says, the continuation of a non-conforming use without that proof.
If I
So
could-
in your answer
Excuse
to
me,
the
Mr.
COs, yes, a CO is issued, certificate of occupancy or certificate of compliance is the document that closes out a permit or that authorizes a change in the use. That information is not there. So clearly, there was a permit to build a building as a two-family. The records continue on, and we have, whether it's a ledger entry or the actual documents showing the progression of this property. Unfortunately, we don't have anything, and nor has the applicant provided any information that would change that. We look, honestly, it's the last thing we want to do is come here and argue over this stuff,
Right.
or to put any property owner through this. But if there was anything, and we've done it in the past, you found a permit that said that we added a kitchen, or we added a bathroom, or there was a alterations or something, we try to push that so that we could make a determination that, yeah, that was the time when they did that. The only thing that we have is the 1979 version of, by the way, a CO that clearly states it covers a permit that was issued for the porches.
Mm-hmm.
And the fact that there's 3 porches is the fact that there's 3 stories in the back of the house. You need 3 porches. It has nothing to do with the use.
Mm-hmm.
But there was a permit for porches, and there was a CO. That CO has been signed twice, with one date, with language added that says it's existing non-conforming and can be used as a 3-family. Where does that come from?
And how does that does the building inspector typically have the authority to suddenly decide that something can be other than it was originally designed?
Not without documentation to support that.
Yeah.
Could I respond briefly? The problem is here, the homeowner is being put in the position of having to find documentation that was within the sole custody of the village. Now, the building inspector just told you. He took permit 137 from 1928, and 145 from 1955, and 339 from 1959 from ledger entries. Where are copies of the actual permits? Where are copies of the certificates of occupancy that close them out? Clearly, there's a giant gap in the village's record keeping. And now a homeowner, 40-something years later, when they have, unless it's accused to be a forgery, when they have an issued certificate of occupancy, having to defend it 40-something years later when we weren't the owners, and having to find out what records that maybe the village can't find because they obviously can't find a chunk of the records that they even refer to as ledger entries, but not copies of existing documents. They never referred to the predate letter that was issued that's a record of theirs. They never referred to the building department 1997 letter, which talked about the use. We don't know if this was made a pre-existing use in 1940, 1950. There's no way of knowing. But it is quite unusual and really, I believe, contrary to law to ask a homeowner 40-something years later to defend their certificate of occupancy. You know, whether you want to ask village council to opine, I don't know. But I've never, in 35 years doing this, I've never had to defend a certificate of occupancy. I've had these kind of conversations when I'm going before you for a variance, looking for a a non-conforming use, and I'm brought to task to prove that everything was done properly and work was done pursuant to code and permits, but not when this village was authorized to and did issue a CO, why the applicant would now have to defend your certificate of occupancy is new ground for me, frankly.
So let me ask this, either, Sean, maybe you can answer first. Has the village reviewed the ledger, the records that it has, which I believe is the ledger, for any permits, like you said, that would add a kitchen or add a bathroom, that would somehow indicate a legalization of a third apartment?
Let me expand on our review of this project as well. And by the way, the laws of record keeping back in 1926 are not the same as we have today. You know, we have the technology now that we save every document, everything is scanned in, everything is documented. We admit that was not the case, 50, 70 years ago. But to actually have the old ledgers that are literally falling apart now, to have that as a reference is a great tool. And we use that. Instead of saying, oh, there's no documents, we actually use it to their advantage and say, if we can find something, we allow the applicants to come in and page through them, if there's anything that can be found. Now, to answer your question, Mr. Chairman, we went a couple steps further on this one. Instead of just opening up the file and saying what's in here, when this issue came up that there's a potential problem with the validity of the CO, we went back and we checked who the previous owner was and who was the previous owner to that. We actually have the original owner's information and how it transpired. We went and took those names and plugged them in and said, go through, look for a name that has that owner's address on it. Did that owner own a different piece of property? Maybe it was filed differently. Maybe it's in a different file and all. We've gone through, we've exhausted it. And as I met with Mr. Vendetti and Mrs. Vendetti and Greg Kane, their real estate attorney, right here in this room, I had the books, I had the file. I said, by all means, have at it. But we could not find any reference.
And I appreciate that.
But if you want to go further into this, where we find that it's problematic, and it only became problematic after that inspection that was conducted. Quite frankly, if it appeared to be a legitimate apartment, it may never have risen to this. But when my certified inspector, who's also a registered architect, went to the property and saw what he saw, it raised a red flag. He said, how could this exist? It appears that it's old, but as mentioned before, there was a problem with the ceiling height. Serious problem with the ceiling height. 6 foot. That would raise a
Excuse me,
flag.
that's not the ceiling height,
that's-
that's the
I'm
doorway.
sorry, I'll get to that.
Please, yeah, don't
We'll
give me
get to that, because we'll get to that. 6 foot, it drops where the pipes were and in the doorway. 6'3" and 6'4" in some cases. There's 2 steps up in the bathroom, which is, by the way, built underneath the front porch. The violation in 1997, which, by the way, that inspector was relieved of his duties from this village, because any inspector who sees that a cooking device is being plugged in with an extension cord into the boiler room, that should raise an eyebrow. Lack of light and ventilation, lack of second means of egress. These are all red flags that we said, wow, how did that happen? And so that's why we pulled the file on it to see. Now, there was a mention about this, and I was accused of omitting this information. By the way, the information that we so-called have omitted is the stuff that was post-1979, because quite frankly, we see what happened after 1979. We also omitted the fact that we've issued 3 COs since that time, and they all say it's a 2-family house, but it was never brought to our attention that you're writing the wrong use on the permit. Okay? They have copies of that. Also, by the way, and I stand corrected. In my letter, I indicate that we issued a title report. It wasn't. It was information to the title company. I stand corrected. It was a mistake by the municipality. And the bottom line is we're allowed to make mistakes, unfortunately. And it's bad that we have to admit that, but unfortunately it happens. I said it was a title report. It wasn't. We sent the permit information to the title company. Okay? But getting back to the variance, you said that I omitted that information. It's crucial information. No, it's not. You know why? Because that variance, and I believe their architect is here and could vouch for this, was applied to New York State at our direction when they were applying to legalize the basement space and connect it to the first floor apartment. Okay? That's how the application went to the state. Okay?
Correct.
And the state came out and granted the variance. We call it a routine variance. And by the way, for the record, the petition from the state says that the petitioner pertains to alterations to an existing two-family dwelling, 2 stories in height, located at 123 New Broadway. They go on to mention about the ceiling height request. Mr. Venditti says that the state approved the basement.
Approve the height of the
That's,
basement.
no, your letter says they approved the basement. How could I omit that? This is the real deal here. This is the document from the state, and they go on to their findings of fact and of importance that everybody should know, because we seem to be the one who's holding this up. Number 7, the local code enforcement official has been consulted in this matter and does not object to granting of the routine variance under the provisions of 19 New York C RR 1205.6. We didn't object to it. We want this thing to go through. But unfortunately, it can't go as a 3-family. That's the fact with the variance.
If I could respond just briefly to that, please, because I think there's a little bit of a mischaracterization. When you read from that about a 2-family, it was applied for that because that's what you told it was after the inspection where you denied the 3-family before we had the CO. So we, in good faith, used the information that you gave us. Don't, you make it sound like it's an admission.
But it's a response to your, it's a response to your letter indicating that the state approved the basement, which is false. They approved a routine variance for the height.
That's correct.
Okay, so that's the end of that.
It didn't say that the state approved the entire basement. We were talking about the height issue. That is very common in these old houses. What we're back to is the issue of the fact that you're being asked to nullify a 3-family certificate of occupancy issued by this village. Do you know how many houses, if you take that precedent, you will potentially place into non-compliance in this village? That in good faith, without the present owners having done any of this work, in good faith relying on the document of your village, an official document, they call it in law a valid and subsisting certificate of occupancy. And by the way, it makes it sound like this apartment is somehow, no, it's actually a very large apartment, okay? It has large rooms, it has windows, it goes to the outside, to the backyard, it's above grade in the back. It's actually an apartment that's larger than many apartments you'd find on some people's 2nd or 3rd floors in multifamily houses. So I really kind of a little object to the characterization of this apartment.
It's not characterization. That's actually, your architect has made plans to correct those problems.
I know, because we
So
were
it's not a
forced.
characterization, that's a fact.
We were
Those
forced
are
to
the
do so,
conditions.
Mr. McCarthy, we were forced to do so after.
I'm sorry, you were never forced to do anything. You were provided with all the information that we had, and you were also told at the time, and you're fully aware as being an attorney, what your options were at the time that you received that information.
We
You were
wanted to
told at the
be,
time you can appeal for a
Sean,
variance.
we wanted to be good neighbors
Well-
and do what was right. But you didn't tell me about this CO. You didn't tell me about this predate letter.
Let's talk
You-
about the predate
You
letter.
didn't tell me
Why is
about
the
Excuse me,
1980,
could I-
why is the
Mr.
19...
McCarthy, could I finish first?
Yeah, oh,
You
I'm
didn't
sorry.
tell me, third thing is, you didn't tell me about the existence of the 1997 letter from the building department calling it a three-family upon actual visual inspection of that apartment.
Again, as I mentioned before, anything past 1979, you actually had the records. You had the records. I didn't put that in my report because it's not relevant to the zoning board's decision. My letter was in response to your application and request to make this a legal three-family and demand that a CO for a three-family be issued.
Do you think a
Okay.
legal three-family
Excuse me.
CO in
Sorry.
1979 is
Can
relevant
we,
to this?
I really try to like to avoid the interruption. And let Mr. McCarthy finish his.
Excuse me.
Well, thank you, but let's go back to, again, and I agree, the nature of the terrain, the whole rear of the basement level is exposed. It can be modified. Their architect has prepared plans that could either connect to the second floor, or if they apply for a variance, it would be probably a fine apartment for people. I think our records only indicated that there was one complaint over the time period that I've been the building inspector. But going back to the file, we have evidence, factual evidence of a two-family permit, okay? To reinstate that, we have a survey, 1951. Doesn't show the porches at the time. That would then coincide with the construction of the porches. We see that the dormers were built. Again, all factual information that goes along with this file. But would have been required if this was converted, whether there was a permit from the village or no zoning or anything, to convert it to a three-family, they would have had to comply with the multiple residence law. Okay, and to do that, under old dwellings, assuming, everyone talks about being grandfathered in, okay, or we can get into the non-conforming part of this whole discussion, but under the multiple residence law, nothing in this chapter shall be construed to require any change in the construction, use, or occupancy of any old or other existing multiple dwellings occupied as such on July 1st, 1952. We can't even go back that far. Because without the porches, you're not getting out of the other apartments. This is the date, just like our 64 date that has been used by this board as long as I can remember.
So what you're saying is that what we had before the permit for the porches is simply a home.
Correct. You
And-
could see from the survey at that time, prior to 1952, the porches were not constructed and therefore could not have complied with this law, which would have been, even if they didn't get a permit from the village, even if they didn't get a variance from the village, they still would have had to comply with this.
And
Just another piece, just as Mr. Vendetti has these pieces post-1979, this is the stuff that we need to get to 79.
That law that Mr. McCarthy talks about, he's talking about rear porches. There always existed the front porches and the stairway up to the second floor. Most houses don't have a front entrance and rear porches coming down. Again, we keep going circular back to the same argument. We have a valid C of O in 1979. And I don't see how you can today in 2020, I wish it was 19, nullify this CO.
So just again, on the point of the porches, when you go from a two-family to a three-family, you're required to have a covered second means of egress. That's why this is important. It's timely with the porch construction. it wasn't a three-family at that time based upon this information. And again, the documents. 1951 was the survey date, I believe. No existence of the porches at that time.
Are you
We're-
saying?
We're
you have-
doing this to try to find a way to get there. But the more we research it, the more we find that it wasn't.
Sean, are you saying that you have village records? Are you making, are you surmising, or are you saying that you have a village record of a survey saying in 1951 this was a two-family house?
No, I think what
So-
Mr. McCarthy is saying is that the application to build the home in 1928 was recorded as a two-family frame. And then the next permit at the property is to add two dormers, which I don't think is
That doesn't
relevant
affect the-
to our discussion.
Yeah.
And then the next permit is in 1959 to erect 3 rear open porches to the dwelling. And that's the first evidence that we have 3 apartment units in the property. And that postdates the 1952 law that said that any pre-existing occupied dwelling can continue to operate as such.
But we have
So
no
what-
way.
You know, what Sean looked for is evidence that this was a 3-family prior to 1952. And not just Sean, but he allowed you to look for it. And we don't see that evidence.
Well,
And you
But
keep
Mr.
saying,
I
Chairman,
think it's
I'm
fair-
sorry, but the evidence is here that you said that yes, we do have the survey. The survey was prepared for Cecilia Ritchie, who was the original owner at the time. It was prepared by Edward Martin Jr., land surveyor. The last date on it is April 3rd, 1951. The document is here.
But that survey doesn't speak to how many apartments there are in. And there's no way that any of us sitting here today, not me, nobody on the board, not Mr. McCarthy, can know that that house was not a 3-family in 1949, and that these porches were built in the 50s to comply with whatever the existing law was.
so what you're saying is that you don't know it was a 3-family in 1952.
But what I do know is that I have a certificate of occupancy so that the village knew it was a legal 3-family.
You-
We keep going back to the same point.
You
You're
have a
looking to.
CFO as of 1979.
That's right. So so I can't speak to what happened in the 50s. For all I know, this could have been a 3-family in 1930. But I do know that this village issued a legal certificate of occupancy in 1979 that they now look to take away, but not one shred of fact other than surmise. Everything has been surmised. I have the only factual evidence here, which is a CO.
Can I ask a question? Can someone explain this to me? It's not the best copy, but it looks to say final village assessment roll. I don't know what the date is. but
2017.
123 New Broadway, 3-family, is that?
Yeah, that was just taken off the assessment roll. There's a bunch of them.
So
I just
that
took it
would-
as a representative
It would
sample.
appear on a assessment roll as a 3-family?
Yes.
Sean?
Yes, and that's been brought before this board numerous times. It's not a legalizing tool.
Okay.
Because unlike what Mr. Vendetti said, he's confusing, by the way, who inspects these properties. He talked to the inspector in the town of Mount Pleasant, who's the building inspector, who clearly doesn't inspect our buildings, but the assessor does. And the assessor is the one who would make the marks in the margin, which, by the way, also doesn't make it legal. Notes are put in the margin for a reason. The actual document gets modified. Our document shows a modification. And again, a date of 1976, a little closer, but still not 64 or 63, at which at some point in time, and again, I don't know who did it. I was not here. I think I was at WI at the time or something, but nonetheless, that's something that an inspector or the assessor would put on there when they notice something, there's a change in the assessment or in the occupancy of a project. There's notes written in the ledger that I have notes all over the place. It doesn't make it legal.
And it's true, and I said it earlier, that in and of itself, I mean, because I've been doing this a long time too, just the tax status of a property doesn't by itself confer legal rights. Taken together with other things, however, and particularly, this does confer legal rights. This is usually what people are arguing about. They're trying to get a predate letter, they're trying to get a variance. They don't come here before you with an actual certificate of occupancy where this has already been decided. And now you're being asked to set an incredibly dangerous precedent for this village and overturn a legal document from 1979 that conferred the right of the owner to know what he was buying, the right of a lender to know what they were lending upon, the right of use and occupancy. There could now be many homes affected by this. You're being asked to take an unprecedented course of overturning a legal certificate of occupancy because documents can't be found that may exist, may not exist, but the documents can't be found by the building department to make someone feel comfortable 41 years later about what the building inspector did in 1979. That's what it all boils down to.
Okay.
And I would just suggest to you that that would be an incredibly dangerous course of action to take for this village.
Well, I think the problem I have with that is that this 423 certificate of occupancy that you refer to is modified by saying this C of O covers the enclosed rear porches.
Yes,
so
and that-
that's the scope.
and that
the
was
scope
standard-
is the 3 porches.
No, this is a 3-family non-conforming building and may continue as such. The building inspector said, this is legal, you can continue to use it. And before that, he said again, this is illegal, this is a 3-family non-conforming building and such use may be continued. You're being asked 41 years later to declare that this building inspector had no legal right to issue this certificate of occupancy. And as I said, someone is here who can speak to this being a very normal way of the way things were conducted. You can see it was stamped twice, signed twice, the village stamp. And this is how they did things back in the 70s. They wrote things, they used their hands, they didn't have computers. When a document didn't have all the information it needed, they wrote on it and then signed it again. So you're being asked to say right now, Mr. Page, Building Inspector Page, you committed a legal error twice when you issued certificates of occupancy and legal predate letters. And I'm just telling you that that would be really an unwise course, not just for me, but on the part of this village. I will tell you there's going to be countless homes by this precedent. In fact, I have a whole list of them to foil, just within a few blocks of homes of the same vintage in the same district that are 3-family or more. And I'm going to bet you dollars to donuts, many of these houses are similarly situated to this exact same thing, and you're not going to find ancient records because you know what? I used to go all the time to the town of Portland for building records, and they had a building inspector, just tell you a quick anecdote, that in the 1960s stored the building records in his basement at home, and he had a flood. He no longer works there. I don't believe that the gentleman is alive any longer. The town of Portland couldn't locate a whole swath of records in about a 2-decade time period. It's a nightmare. You know, people didn't keep good records in the 20s, 30s, 40s, 50s. I don't know when this building was built, when files were brought over here, where they ended up. All I know is I have your certificate of occupancy issued by the authorized employee of this village with power and authority and jurisdiction over land use. And he issued it. So I'm not even sure what I'm here arguing about.
Sean, no, we have zoning board records, correct?
Correct.
And they go back a long way, correct?
20s, yes,
To the 20s.
correct.
Any record of this coming up for a variance for a 3-family?
No. I think I mentioned it before, but we did the same process, going through the zoning records to determine whether or not it was under a different address, a different owner, or something that would have raised an eyebrow here. Just does not exist.
And
So the claim that, you know, we don't have the documents is because it didn't happen. We have actually great documents. I could pull out the 1898 ordinance right now for you. I have the document. I have the 26 document. We have these records. Sure, there may be some, absolutely, it's possible. They were handwritten into a log and then thrown out. But at least there's something, and it is actually, as we know, it is legal. If we exhaust our efforts to find these documents and they're certified that they're not there, then that's what you go with, unfortunately. As much as I would like to pull a document and just make some corrections in the basement and move on, you can't do it. But what's important and what's being overlooked here is that our code and New York State law allows for the revocation or suspension of certificates. And specifically, if the building inspector determines that a certificate of occupancy or certificate of compliance or a temporary certificate was issued in error because of incorrect, inaccurate, or incomplete information, and if the relevant deficiencies are not corrected as to the satisfaction of the building inspector within such a period of time, we can revoke the certificate. As much as nobody wants to get to that point, and that's why we try to make every effort to take it in a different course to allow the space to continue to be used, maybe not as an apartment, but as part of the house, or apply for the variance. They were given those options. We don't want to pull the permit, pull the CO. But the attorneys here know what the case law is on this.
That's correct, and
Parkview Associates and that, these things happen.
and that
They
law,
added 19 stories to the building, whatever, and, there was a mistake that was made there. We
And-
feel that there was a mistake when this revised document was issued.
now, I can say that that law is totally cited out of context. That's usually the situation if, like was just pointed out, someone had approval to go to 18 stories and they went to 19. Or, they submitted a survey and showed they had 2 acres, and then it turned out on resurveying they only had 1.5 acres. This isn't an error. There's been no showing that this is a mistake. And this isn't a single instance. There's numerous instances where it was certified. All that has been said is that there are not documents that the building department can locate to support it. It does not say that Mr. Page made an error in 79, the month before in 79, or in 1980. And what the building department does admit is that even on this house itself, you're missing records. You're missing the 1929 certificate of occupancy. You don't have the
We
permit.
never said we're missing it. We said it does not exist.
It just also is never issued, but there's never been
People
any-
just don't get a CO because they built something. They actually have to apply for it.
Well,
Yeah.
but you also
We
know that-
issue certificates very often throughout the village for historical construction. People are selling a house, they've owned it for 30 years, they come in, they have 10 open permits. They close them out.
and they have to be closed, just as we had to close the permits. But they don't have that. He even said that, who knows?
We're not
it might have
missing
been,
documents.
It might have been thrown away. And then the 1955 and 59 permits, they're from the ledger. No documents. They might have been thrown away. No certificate. So you're saying that permit after permit wasn't closed, yet they then
We
later on...
acknowledge the 1979, we acknowledge you keep beating us to death here, but we acknowledge the 1979 certificate. However, it is for the porches. And nothing in the record, nothing that has been presented historically shows that a 3-family use got linked to that.
That's
by
not
a building
correct, Mr.
inspector's arbitrary decision to write that on there.
But-
Okay? There was an arbitrary decision that modified a document with no backup information. And to make it worse, when it was reissued in 1980, all that information was not on there anymore. Why is that?
It wasn't
Isn't that
reissued.
very important? If I received that document and the 3-family non-conforming stuff is all gone.
It would be very interesting if that was correct. but it wasn't a reissuance of a certificate of occupancy in 1980. If you read that document, it was to whom it may concern, it was just a reference
Right.
that a CO was issued in 1979. Please, let me finish.
And you as an attorney wouldn't question that? I
Excuse
know
me.
if you were on the other side purchasing this property, you'd be doing the same
The
thing I'm
property was
doing
already
right now and saying, geez, my client is buying this, I want to make sure he's buying a three-family, and this document looks fishy.
That's,
That's
we're
part of the
we're
problem,
misstating
is
the
it
facts.
really
That was
does
not
look
for the purchase. That was after they already purchased the house. The one for
No,
the
I'm
purchase,
just making a general
the
statement.
one for the purchase is 1979. The building inspector just admitted it was issued, yet he misspoke and said it was for the porches. It was not. It was, this is a three-family, non-conforming building and may continue as such. The CO covers the enclosed porches. That's what this CO says, and that's what was issued by this village. And there's been nothing to show this person lacked the authority or the information at that time to do it. All that's been shown or alleged is that you don't find other documents. Again, I'm not here for a variance. I'm not here for an interpretation of pre-existing use. I'm here to uphold your 1979 certificate of occupancy.
And
We
how does the
understand that.
property get to become non-conforming? Are we forgetting?
Well, I have a question on that.
Yes.
So, what's your end game? Are you trying to sell the property as a three-family
Correct.
building?
We were in
So you're
contact.
not doing any renovation, let me speak. You're not doing any renovations to this to conform the basement to a livable space?
What we're doing is, when we first were issued the denial before we found the CO, we went and we engaged, and he's here, Mr. J.B. Hernandez, our architect, to draw up plans to try to connect it to the first floor. Of course, there's a tremendous loss in value going from a three-family to a two-family
Sure.
house. And I think anyone here would want to keep a three-family that they bought as a three-family with a legal certificate of occupancy. So we started that process. And then, in the course of selling the house next door and going through papers, the CO was found.
So you want to keep the house as a three-family,
Obviously-
not do any renovations to the basement?
Well,
Not bring them up to code, or?
If we choose to, that could be a choice,
Yeah,
because
okay.
it's already non,
it hasn't
To me,
been
this
touched.
doesn't mean, that doesn't mean anything to me either, frankly, because I agree with Sean, it's a enclosed rear porch C of O. A C of O is not saying that you're a family house,
It says right here, this is a three-family.
attached to a C of O.
He doesn't have the authority to change the zoning.
But we don't know that he did that. No one knows that he did that. All we know
We don't
is
have
that
any
you can't
evidence.
find the records, and there are admittedly numerous records missing from this file over the last 100 years.
No, I don't think there's any admission on the part of the village that there are missing records leading up to the 1952 change in the law. You have a ledger that you were able to review, and you can see in the ledger what permits were applied for originally and subsequently.
And why doesn't the ledger indicate when those permits were closed out? And
Because it's been explained many times at this point that not every permit's closed out.
But we also know for any permit, there's a permit application. There's an application form. There's plans and things filled out. Where are those application forms? That might shed a lot of light on here to see what was stamped approved in 1955, 1930-something. There's an application. Where are those documents?
And that is the point of the ledger entries. These documents no longer exist because they were disposed of.
And
As
that's what I just said.
As nowadays, we will scan them, so there's a computer file, and then they would be disposed of. In 1926 or 1928 and 35 and 37, as we go along here, those documents were disposed of.
And that creates an impossible burden for a home.
But there was a
homeowner.
reference in the ledger that our village clerk will certify that that is accurate information and part of the documentation in the village. And that's accepted by other people purchasing properties and other attorneys.
And this CO
How
is
come it's-
referenced in your ledger.
So the question on nonconformity can only be established when the use of the property was established prior to the adoption of the zoning ordinance. So when you have a permit for a two-family house and the zoning ordinance changes to allow only one, it's not non-conforming, it's conforming. If you change it after that time, okay? Yeah.
Again, we keep getting confused. I don't want to take up all your evening, but we're not looking for a variance. We have a certificate of occupancy.
No, we understand.
It's a legal document that this village issued, and now the onus is being flipped around from the village record keeping to an owner that didn't own this property 50, 60, 70, 80 years ago.
Are there any other questions from the board for the applicant?
If I could address the board.
Are you,
Thank you.
I'm sorry, you are,
Robert Ponzini.
okay, can I, let me open the public hearing first.
We should open it for
Okay.
comments.
with us as part of the application.
I know.
I would open the public hearing.
Yeah, I think it's proper to open the public hearing. It doesn't matter, I don't think it makes a difference. So I'd make a motion to open the public hearing.
Second?
All in favor?
Aye.
Okay.
Also, if you may want to accept onto the record the New York State variance that Mr. McCarthy referenced.
Yes, I think that would be very helpful.
Yes.
Thank you very much. My name is Robert Ponzini. I'm an attorney with David's firm. That's why my name is in it, Gaines, Novick, Ponzini, Casso and Venditti. I'm not going to repeat all of the facts. I've known Sean for a very long time. He's a very fine building inspector. I have no problem with his work, but I disagree with his opinion. I disagree with his findings. It's a little bit like they talk about the Supreme Court of the United States. They're all brilliant. Sometimes they vote 5-4. They have differences of opinion. They look at the same facts. They see things differently. I had the pleasure and honor to be village attorney in Sleepy Hollow starting, I guess, I can't remember that far back, around 78 or 79, somewhere in there. And I was village attorney pretty much for over 20 years, right into the 2000s. And I saw the way the village operated then and the way it changed. Kind of scares me, by the way, when I think that far back. I guess I'm glad I made it this far, but then I realized how old I am that I got here. And the only reason I was really aware of this case is because David was going through the file and I saw the letter of no violations, and there was my name on the letterhead. And that was the common practice at the time. With correspondence, they would just use the official letterhead, and the building inspector would use it for his communications. So I saw it and I said, oh, Dave, I'm familiar with that. And I knew Randy Page, and he was the building inspector at the time. And it was a common practice at that time that if someone was buying or selling a house, the title company would come in and he would issue generally first, a record of no violations. That would be the first thing. In this particular case, he also issued a certificate of occupancy. It's my understanding, not that I was with him 24 hours a day, but just knowing generally how the building department operated at that time, and I also did the prosecutions of the village on zoning code violations, that there was a very good likelihood that Mr. Page would have gone to the site, looked at it, done a visual inspection, and then come to his own conclusions. Now, I certainly can't discuss the records prior to 1979. I have absolutely no idea about them. I don't know if someone came in and there was a building inspector in that period of time who let somebody build something and it was very laissez-faire. I don't know that. All I know is the proof that's in the record. You know, they say as trial attorneys sometimes, cases are won and lost on proof, not on speculation. And there's nothing better than having a document that proves what you want to say. And if you have an official document of a municipality, that's really called evidence in chief. That's given a high degree of respect by any court. Now, the Zoning Board of Appeals is a quasi-judicial board. You really enforce the zoning law, and you know that. I'm not telling you something you don't know. So I'm telling you, it's my belief that having a certificate of occupancy is evidence in chief. Now, subsequent to that date, there was a visit to that property, as I can see from the record, by the fire inspector, and they did an inspection. And then Mr. Margada also made a comment, and he was the building inspector, that it was a three-family house. Now, the only person here who can't speak for the status of the house is the Cortados, who are now deceased. But certainly when they bought this property in 1979, they were immigrants from Spain, hardworking people. They wanted to live in this community. And they saw the only way that they could buy a property in this community is if they had rent from three tenants. So they bought this building, they hired a lawyer, he came down to Village Hall, he got a certificate of occupancy, he gave it to the bank looked at it and said, oh, you can have 3 tenants, this is the income you'll get, we'll give you the loan. He gave it to a title company, his lawyer would have. The title company said, oh, you have no violations, we're gonna certify the title, congratulations, now you owe a 3-family house. And they owned that 3-family house for 41 years. They paid taxes on the 3-family house for 41 years. They never had any problems with their neighbors, complaints with their neighbors about too many people on the block, people parking too many cars for 41 years. You know, you're going to make a ruling based on the law, but there's also a doctrine in the law. It's called laches, okay? And that means when you do something for a very long period of time, and it's really open and notorious, you can't put the burden on the other person based on your failure to enforce it. You know, these people left this building to their family. This is something they were proud of. They provided good housing for residents of this village. They paid good taxes, and now they want to pass on what they built and what they developed to their family. And it seems only because they can't recreate all that happened prior to 1979 that they're going to lose that opportunity. Like I said, I don't want to go over the facts. I think Mr. Venditti's made a very good record. I understand Mr. McCarthy's arguments. I respect them. But I really think it would be a disservice not to allow this as a 3-family. It's not like someone, you know, when building inspectors drive around, and yeah, everyone likes to say it, but I'm almost as old as your counsel here. And we've been in the municipal law business for a very long time. Buildings inspectors go around, they go, did you put a swimming pool in the backyard? Did you put a porch on that you're not supposed to? Did you put on an addition? Did you stick out a dormer so you get an illegal apartment? Did you do something like that? This building was never modified. They never put in anything else in that 3rd apartment. It was the way they got it, and they maintained it from the day they got it to the day they died. All the same. So thank you very much for your time. Thank you for your patience. I appreciate it.
Thank you. And is there anyone else from the public that would like to speak on the application? Okay, I'll make a motion to close the public hearing.
Second.
All in favor? Does the board have any other questions for the applicant? Do
Mr.
you-
Chairman, could I ask for a sidebar for the board, the attorney, and Mr. McCarthy?
And
Ask
in
for a sidebar,
terms of
please?
going into executive session
Yes,
with
please.
counsel, yeah. So I think that's appropriate. I think we want to make sure we're applying the right standards. So I make a motion to go into executive session.
Second.
All in favor? We're all back in session.
We're just waiting on,
Oh, sorry. Sorry.
You should move to leave executive session when Ms. Rubik comes back.
Thank you. Okay, I make a motion to leave the executive session.
Second?
All in favor?
Aye.
I'll ask the applicant if there's anything left to say.
No, nothing further. Thank you for your time tonight.
Thank you. So I'm going to make a motion to reject the reinterpretation of Mr. McCarthy's denial to issue a certificate of occupancy for a three-family residence. I am sympathetic to the application, but I think clearly the board has the ability, and the building inspector has the ability to review the propriety of prior certificates of occupancy. And here we have a building in the village ledger that indicates it was built in 1928-29 as a two-family, and that there was nothing done between that date and 1952 to transform it to a three-family. And that search was exhaustive, including a search of the building department records, including the ledger and the zoning board of appeal minutes and decisions, which did not reveal any effort to convert the two-family into a three-family. We have a document titled Certificate of Occupancy, but that also says this C of O covers the enclosed rear porches, and the following correspondence, really the letters, really don't, are indications, but they're not proof that there was steps taken to make this a valid three-family home. The one issue on precedent, which we heard a lot of, there actually is precedent, in my view, a prior application, the Evangelo application, that's 77 New Broadway, where the building inspector, really numerous times, my recollection is, told Jim Evangelo that he had a four-family building, and the records just did not reveal that. And he came before the board to change the building department's refusal to grant the four-family C of O, and the board rejected that application. So I think we have a similar situation here.
He had a previous four-family CO?
He had a minimum, a building inspector repeatedly say to him that he had a legal four-family.
Not quite the same. I understand.
And came before the board, and the board rejected that application. The bottom line is there's a zoning code, and the building inspector doesn't have the ability to override the zoning code. And if he does so in error, and Mr. McCarthy reviews a new application and determines that there is a potential error and refuses to reissue an erroneous certificate of occupancy, you're now before the board for review of that decision, and I think everything Mr. McCarthy did was within his proper exercise of discretion. Does the board have any other comment before I make a motion on the application?
Sorry?
Does the board have any other comments before I make a motion on the application?
No.
Okay, so again, I make a motion to deny the application. So to deny the application that the building inspector is in error for his denial to issue a certificate of occupancy for a three-family residence. Is there a second?
Second.
All in favor? Thank you.
Thank you. Is there a full transcript available of the proceedings tonight? And where do you order that from?
I don't know if there, you can order a transcript, but I do know the village is posting the zoning board meetings on the web.
A recording of it?
This is recorded.
Yes.
Thank you very much.
Thank you.
There will be minutes as well.
Thank you. Good night.
Good night.
Thank you.
Thank you. Okay, moving to application 5, and thank you for your patience. I'll read the public notice. It says, please take notice that the Zoning Board of Appeals of the Village of Sleepy Hollow will hold a public hearing on Wednesday, October 21st, 2020, at 8 p.m. to hear and consider the application by Saving Gatfield to construct a covered front porch addition to the existing single-family residence where the following variance from Chapter 450 of the Code of the Village of Sleepy Hollow is required. Article 6, 450-35, Schedule of Regulations, minimum front yard setback 30 feet, existing front yard setback 30.41 feet, proposed front yard setback 23.5 feet. The property involved in the application is located at 2 Harwood Avenue, is situated in the R2 zoning district, and is shown on town tax assessment maps as Section 110.19, Block 2, Lot 63. A copy of the application and accompanying documents are available for review at the Department of Architecture, Land Use Development, Buildings, and Building Compliance during normal business hours, or may be reviewed and downloaded from the village's website. All people are entitled to attend and be heard at this public hearing. Village Hall is accessible to persons with disabilities. Pamela, are all the returns in for this application? Thank you. So I have before me the Zoning Board of Appeals application, forms 1 through 4. I have the short environmental assessment form, photographs of the Gatfield residence from Frank Tancredi, the architect, the deed, what appears to be the deed, and the plans submitted. So yes, you may-
Mr. Chairman, if I could just interrupt, I am in the notification zone, so I'm going to recuse myself from this particular decision.
So just very briefly, there's only going to be 4 voting members of the board tonight.
Okay, good evening, I'm Frank Tancredi, the architect, here with Savin Gatfield, here with the owner. We're here tonight to present our application, as you have read, to create a new front porch, portico/porch combined. That's the area here with the hashing in front. Currently, we submitted photos, but you really can't see it on the photo per se. You know, the front stoop is of concrete and of a, bluestone or flagstone, which is in need of repair. That's the genesis of this application. Being that it's on the northern side of the house, it doesn't get much, afternoon sunlight, so that, snow buildup or ice, in the heavy winter months, create the problem. So that's where the roof structure comes into play to offer some protection for the elements, but also some protection, from the sun. There's a deck on the back of the house, but now there's a need to put an area on the front where the family can sit and enjoy some evenings or just to be out in the sun a little bit. Currently, the house is on the corner lot. I did have a conversation via email with Mr. McCarthy, Sean, about you know, what are the requirements for a corner lot and which, you know, front yard, side yard and whatnot. And we came, front side equal to front. We came to the same consensus that this is, you know, best that we stay consistent with the original zoning of the house built in 1960. Was it 3? 3. 63. That's what I, you know, the plans were done in 62.
But that is correct.
Where Harwood was considered, you know, the legal frontage. But technically, as we stand today, Broadway, the wider street, is the legal front, and this would have to, you know, could be 30 feet, but if the property was, the lot was created before the zoning was adopted, we could cut that down to 15 feet, correct? Half.
That's correct.
So we're here for a variance, but technically, you know, we're looking at the, you know, the consistency of the streetscape. You know, so that's why we're before you. Did you want to add anything to it?
No, nothing.
If there's any questions, you can see on the back page, you know, proposed elevation, coming straight out, and you know, we're going to redo the walkway to the street, and you know, all the elements of the structure are going to be consistent with the, you know, the colonial style of the home and neighboring properties throughout the, you know, Phillips Manor. And that's pretty much our application.
Is the porch enclosed?
It's not, it's just railing, not enclosed. You know, it's just roof and railing, so it's open structure.
On the only part that's actually, perhaps some roof is right by the door.
All across here, this is all,
Oh,
this is, by the door, it's more accentuated to look like a portico, and then you know, it stretches across the front. And that's where, you know, people can sit down and enjoy, you know, the night air, or being out in the sun. And, you know, today with COVID, you know, you have to get out of your house. So, you know, it's a good thing. And it also balances the house a little bit, you know, being at this, you know, the garage being on the bottom, you know, kind of anchors it a little bit more advanced on the east side.
Essentially, what you're saying is it would not be aesthetic to put it on the side of the house.
Correct.
Not, at least not as aesthetic.
Right. But there again, you know, keep in mind what I said earlier, the first thing, the front stoop needs to be reworked. It's, you know, it's time to fix it. This gives them an opportunity to do that and then to utilize, you know, that area as well for, you know, family and whatnot. Again, it's the end. It's not the middle of the street. This is the end where it bends.
Mm-hmm.
So what we're asking, I feel, is substantial, given the location of this house at the end of Harwood Street Avenue as it turns into 9 and Route 9. And you know, it's a little higher up here in elevation, so you really don't see that. You know, you don't see that.
Does the board have any questions?
and if you were going to keep also, I'm looking at the picture of the house,
At the picture.
would you be also keeping the same bushes are there, so it's almost, or you're going to remove them?
These bushes would have to be removed.
Okay,
Because they're going to be in the way of the new walkway
Right,
that's going to
okay.
come out. And these bushes here, you know, might be trimmed back a little bit, so we're not just like
okay.
claustrophobic, you know, but it'll still be maintaining these bushes here, correct?
Yeah.
My assumption?
Okay.
Yeah, and then any planting that would, you know, be added later, you know, in front of this, what I show is the lattice on my drawing.
Mm-hmm.
You know, it's just not gonna be plain, you know, they're gonna have some planting here and along the side wall, driveway, you know, some growing and stuff.
And the sidewalk is following the same,
And for now, you know, we're looking at taking the sidewalk straight out to the street as all the other homes have, you know,
I see.
something coming
Oh.
straight out. Yeah,
Straight out?
yeah.
Should be noted too that they've kept the depth of the porch really to a minimum that you'd need to have people sitting out there. and which, again, impacts the variance to make it the least
Right.
variance that they need,
Okay.
which is
Yeah,
a
thank
good
you for
thing.
noting that.
Yep.
7 feet, you came out on 7, which is any less is really, it's not
It's
useful.
kind of not practical then.
Yeah.
Okay, I'll make a motion to open the public hearing.
Second?
All in favor?
Aye.
Is there anyone from the public that would like to speak on the application? Make a motion to close the public hearing.
Second.
All in favor?
Aye.
Does anyone want to make a motion? I'll do it.
Oh,
So I think obviously the porch does not add on any undesirable change to the neighborhood. It's an improvement to the aesthetics of the neighborhood, especially if it was put in any other location. This is really a de minimis variance. We're only going from 30 to 23 and a half feet. And as Mr. McCarthy pointed out, that's really the least that porch could be constructed where it could safely house people to sit. It's not an enclosed porch. It doesn't go through the entire front of the house, just part of it. It absolutely doesn't have any physical environmental impact to the neighborhood. Although it's self-created, that's not our only consideration. So I would make a motion, and there is no public opposition as well. So I would make a motion to approve the variance.
Second.
All in favor?
Aye.
Thank you very much.
thank you very much.
Thank
You have a good night. Good
Do you need these?
Unless you want. No, I have my copy. Thank you. Thank you.
So very briefly, we have minutes from July,
Yeah, we have these.
and all we did was wish Tim Judge the best.
Yeah.
So,
I think we can.
so I will make a motion to approve the minutes as drafted. Thank you very much, Pamela.
Second.
All in favor?
Aye.
Okay.
Good night, everybody. Thank you.
Good night. And I will make a motion to close the meeting.
Second?
All in favor?
Aye.
She,